Broadcasting live from the Buckhead Business Radio X studios in Atlanta, Georgia, it's time for Atlanta Legal Experts.
Good morning. Welcome to the inaugural show of the Atlanta Legal Experts radio show. I am your host, Emily Rowell with Crown Office Suites. We also have Rich Casanova here with Buckhead Business Radio X in the background, working as a producer/engineer today. Our special guests of our show today are Kurt Hilbert and Bob Williams from the Hilbert Law Firm. Thank you for being here today.
Thank you.
You're welcome.
And Mr. Jamie Bendel, attorney and owner of the local comedy club, The Punchline.
Good morning.
This is going to be a great show. I'm excited. Okay, so we will start with Mr. Kurt Hilbert. Just wanted to do a quick bio for Kurt. He is the managing member and founder of the Hilbert Law Firm, LLC. He is a seasoned litigator, repeatedly honored by his peers as a Georgia Rising Star super lawyer. He has crafted a practice that provides a wide array of services to clients ranging from banking institutions and large corporations to small businesses. Hilbert is also a certified civil mediator in the state of Georgia. His primary areas of expertise involve real estate, banking, employment, and corporate matters. Hilbert oversees all matters and cases at the firm to provide comprehensive customer service. And he has been hired as a legal expert in several real estate, lending, and title matters, so you are the expert today. So I'm glad you're on the Atlanta Legal Experts show.
Well, I'm very, very glad to be here, and especially for your inaugural show. It's fantastic that you invited us to come down today.
Yes, thank you. Okay, so what do you do when a bank sends you a notice of default on your mortgage? Yikes.
The wonderful foreclosure problem. Basically, I've represented clients on both sides of this problem, both the bank side as well as the individuals, homeowners. So what do you do when a notice of foreclosure comes in the mail? And well, the first thing you do is call a lawyer.
Okay.
Whatever you do, do not call the lender directly, and do not call the law firm foreclosure firm directly, because there are a lot of pitfalls that can happen if you do so. Contact a lawyer immediately, and that lawyer will say what their capacity is that they represent either the lender or someone else that they represent. But the first person you should always call is the lawyer. Document everything. You'll receive a notice, and the first notice you get from the bank is a notice of default, or what we also call a notice of acceleration. And then you'll get a second letter, which is an FDCPA notice, a Fair Debt Collection Practices notice. When you get those documents, there are specific instructions in there that the foreclosing attorneys will tell you to do, one of which is the most critical, which is called a validation of debt. You have 30 days to send a notice in writing back to the lender to actually validate what the indebtedness is, how much is owed, and what the bank and what the foreclosing lawyers are claiming is due to the bank. So when you get that notice, first thing to do, call the lawyer. The lawyer then will help you write a letter back to the bank and to the foreclosing attorneys. Why is that important? Well, banks nowadays, even though these routinely happen, and particularly in Georgia, we're one of the highest foreclosure states in the nation. Bank documents sometimes are internally inconsistent. So when I represent an individual homeowner, the first thing I do is I go back to the loan documents, the truth in lending statements, and look for RESPA violations or truth in lending violations. You'll be amazed at how many banks over the years use an amalgam of different contracts. And over time, they change, but the banks internally do not see if those particular provisions work with the rest of the contract and the document.
Gotcha.
So when you get to the lawyer, make sure you have all of your documentation, make sure you have all the closing package, all of the applications, as well as the security deed and the warranty deed, and so on and so forth. The next step is the notice of foreclosure. Along with your notice of default, there will be a publication notice that will come to the homeowner. That ultimately gets published in the newspaper.
Okay.
When you look at that notice, you have to fly-spec it because there are also some problems sometimes in that notice. And if there is any kind of problem with the notice, those are strictly construed under Georgia law. So if there's even a slight problem with the legal description or the names of the parties or the amount of the loan, it can be thrown out by a
Oh, wow.
court. So it's very important to look at the notice itself. When you're sending notices back to the bank and back to the foreclosing lawyers, always send it certified mail, return receipt requested. It's nowadays, I hate to say this, but a lot of banks intentionally lose documents.
Oh, wow.
And when homeowners are giving notices back to the bank of, I want a validation of my debt, many times those notices can conveniently disappear.
So you probably want it signed.
Exactly.
A signature.
You want a signature saying that I did send it on this such and such a date, and get a green card back saying that I actually sent it to the to the bank. The other part of this that is extremely important is there's a federal program called the HAMP program. I wanted to emphasize that this morning. Many people think that the HAMP program is something that can protect your house and you have a right or private cause of action under that statute. You do not. Even though it is a federal law, you cannot sue a bank or a foreclosing law firm for any kind of a violation of that statute. It is not intended to give a private cause of action or damages. However, I have been successful in arguing that the HAMP program itself creates a duty under state law. And what can happen is the bank will say to the homeowner, we want you to be a part of this program. We want you to stay in your house. We want to modify your loan or do something to help you. And so what's important about that is the minute that they say we want to put you into the HAMP program and you need to provide us documentation, financial statements, and the like, the most important part of that is get something in writing from the lender that they will forbear from continuing with the foreclosure.
Okay.
Many times what the bank will do is they'll say, hey, we're going to put you into the HAMP program, but they'll send you something in writing in the mail saying, basically, we're going to continue our foreclosure efforts regardless of the fact that you're being considered for this HAMP program. That does not protect you.
Right.
What that means is we're going to still go and foreclose in your house and cry it out on the courthouse steps on the first Tuesday, after 4 weeks of consecutive published notification in the legal organ of the newspaper.
Gotcha.
So you're the homeowner thinking, hey, I've got protection under the HAMP program, under federal law. They're not going to take my house. Well, yes, they will, unless you get something in writing. And the Georgia common law that protects a homeowner in that circumstance is what's called promissory estoppel. It's an equitable doctrine. It's contractual in nature. When the bank says, I'm offering a modification under the HAMP program, the homeowner then can rely on that statement to their detriment. If the bank continues to go and foreclose, I actually have a current case right now against a bank that I'll leave nameless. But,
I bank with nameless.
Yeah. But we were successfully arguing that, in fact, there was an offer and acceptance between the bank and the homeowner, and they actually agreed to forbear from foreclosing. However, the right hand was not talking to the left hand, and the bank didn't tell the foreclosing attorneys that they had told the homeowner that they're not going to foreclose. And of course, the lawyers went forward and foreclosed on the house. So we have a whole mess on our hands in trying to get out of that and get the homeowners home back and all the rest of it, including damages and emotional distress.
Hence why they need an attorney.
It's exactly right. Yes. Yes.
Gotcha.
So those are the things I wanted to emphasize about what to do when a foreclosure notice comes in the mail.
That's good to know. I mean, I don't think a lot of people think about that. They just panic and.
Yeah, well, it's your home is your most private and coveted asset, and if you lose your house, you're losing quite a bit, and you're losing everything. And the waters to navigate through those waters is very complex, and the foreclosing law firm will not help you in any way, shape, or form. No. They will not tell you what to do, what not to do. They cannot negotiate anything with regard to the loan on behalf of the lender, believe it or not. Even though they're an agent of the lender actually doing the foreclosure, they're not a debt collector, and they are not someone that can actually negotiate a modification on your behalf. So when you get the letter from the lawyer, your first instinct is, let me call that lawyer and try to tell them to leave me alone and help me out of this. And I need more time, or I had a medical emergency in my family and I can't make my monthly bills, or something to that effect. That is the last person you need to be talking to. Okay. So just to emphasize those points this morning, I wanted to emphasize that because I come across that almost daily in my practice.
Right. Well, that's interesting. That's very good to know. 5 things you didn't know. Not you, but 5 things the general public, I would say, did not know about arbitration.
Arbitration is one of my favorite topics to talk about, and I do quite a bit of alternative dispute resolution. That's ADR. Arbitration is one form of that. I'm a certified mediator, as you did in the announcement to begin with today. And arbitration is basically a binding form of informal dispute resolution. And not a lot of people know what arbitration is. But again, getting back to banking contracts, sometimes banks will put arbitration provisions into the loan documents. So in other words, if there is a dispute under the contract of some sort or fashion, you don't have a remedy in court any longer. You are required to go to informal, binding, mandatory arbitration. So I wanted to highlight 5, actually 6 things today that may surprise people about arbitration or that they did not know. The first is arbitration is a matter of contract. So under Georgia law, everyone has a freedom to contract under the Georgia Constitution, and just like anything, you can agree to the terms. But arbitration provisions are a contract within a contract. The actual arbitration provision itself is a contract. And what a lot of people don't know is you can alter the terms of that arbitration provision to assist you in the outcome of your dispute later on down the road. Now, it's very difficult, obviously, to predict at the beginning of a contract what's going to go wrong or what's going to happen. But at least you can put some things into contractual language to limit exposure, limit attorney's fees, and things of that nature down the road. So what I wanted to emphasize on that is there are 2 particular types of laws that apply to arbitration. Under Georgia law, it's the Georgia Arbitration Code. Under federal law, it's the Federal Arbitration Act. The 2 statutes are somewhat different. Georgia law has a more strict construction than the Federal Arbitration Act. There's a national public policy in favor of arbitration, but under Georgia law, if the provision doesn't have initials underneath it, it can be held to be unenforceable because it doesn't comply with the Georgia Arbitration Code.
Gotcha.
There's no
Totally different from the
different from the federal. The federal, you don't require any kind of initialing. If you have a arbitration provision, it's enforceable under the Federal Arbitration Act. So what the other things that I wanted to point out is under Georgia law, personal injury, Jamie will probably know this, personal injury claims are not arbitrable in the state of Georgia. Again, it's as a matter of public policy. When someone loses life or limb, they think that they should have a constitutional right to a jury trial at all times and not be able to be forced to go into an arbitration, which has very limiting outcomes. Under the Georgia Arbitration Code, there are several different other categories that will limit the applicability of arbitration, but we won't get into those today. I'll just state for the purposes of the listeners that if you go to the arbitration code, it's OCGA 991 at SEC, and you can look at the enumerated factors that what can and cannot be arbitrated under Georgia law.
Okay.
But these are the things that under the contract that you can manipulate when you're drafting an arbitration provision. And this goes out to all those corporate attorneys out there who are drafting these provisions. Many of them obviously have not arbitrated a day in their lives and they haven't litigated, yet they're drafting these provisions anticipating what's going to come down the road when they really don't have the knowledge or the personal knowledge of what could happen. So these are the things that I'm going to emphasize of what needs to be in an arbitration provision. Number 1, the parties. And the most fundamental thing to start with is who is bound by the arbitration provision. Typically, it's just the signatories under the contract, but you also have to consider non-signatories. For instance, in a construction contract, you've got a general contractor, and then he hires out multiple subcontractors. Well, it's going to be far and few between that the subcontractors actually sign or initial the arbitration provision of the underlying construction contract. So I happen to be in a case that went up to the Court of Appeals that set the law in Georgia on this very issue. that there's, a doctrine called equitable estoppel, where my clients were estopped from saying we can't go to court against the subcontractors separately from the GC because they had agreed to arbitration against the GC. So what the Court of Appeals held was, since the subcontractors are a part of the overall construction agreement, those non-signatories could compel my clients to go to arbitration, even though my clients had not agreed to arbitrate with those subcontractors.
Gotcha.
So it's kind of interesting.
Yeah.
Even non-signatories to a contract can be held to go to mandatory arbitration.
So, Kurt, can you exclude someone from arbitration in the contract? Would be the follow-up.
That's a good question.
Yeah, the answer to that is yes. You can expressly exclude parties that you do not want to arbitrate with. My suggestion would be, depending on what side of the contract you're on, that if you were the corporate side of the contract, that you would want everybody to be bound by that mandatory arbitration provision. Obviously, on the flip side of that, if you're the buyer, the person enlisting the services of a contractor, for instance, you want to limit those folks, because the reason being is arbitration is a very narrowly tailored proceeding.
Mm-hmm.
You don't have a right to a jury trial. You have a mandatory finding by either one arbitrator or three arbitrators. And once that decision comes down, one of the things I'm going to talk about here in a moment is about appeals, right of appeals. There's a misconception out there that you cannot appeal an arbitration. Well, there are certain limited circumstances where you can appeal, but when you're dealing with this and you're a homeowner, you want to limit those parties who are going to go to arbitration. You want to have the broadest protections, and where are the broadest protections? In court.
Gotcha.
So the parties is the first thing. The scope of the arbitration would be the second thing that I would certainly want the arbitration provision to specify. The term is arbitrability. What actually can be arbitrated? Obviously, if you are the builder developer, you want everything under God's green earth to be included in that. You want the broadest, most expansive definition possible. Mm-hmm. If you're the homeowner, obviously, not all things should be arbitrated. The next part, this is critical, is the time of the arbitration. You can literally put a statute of limitations, if you will, in the arbitration provision, saying that if a dispute arises, both parties have 6 months to demand arbitration. Otherwise, the entire dispute is waived.
Oh, wow.
A lot of people don't know that you can actually do that in an arbitration provision. Statute of limitations have been upheld both under Georgia law as well as under the Federal Arbitration Act in federal court. So if you want to limit your exposure, the best thing to do is say, if you got a dispute, you got exactly 6 months to think about who you're going to sue, what you're going to sue about, and what damages you're going to receive. And if you do not act within that 6 month period, you're deemed to have waived it.
Okay.
So that's something from a corporate standpoint. A lot of corporate in-house counsel should know that is something that they can do to protect the company. Not a lot of corporate counsel know that. The next part is obviously the procedural part of the arbitration. You have much more flexibility with regard to evidence and tendering of evidence in arbitration than you do in the court of law. The rules of evidence do not apply. They're very lax. So you essentially can tender whatever you want to the arbitrator or arbitrators, whichever it may be, to prove your claim. And then the arbitrator ultimately decides what evidence is relevant or not, and so on and so forth. The most critical point of an arbitration has to do with attorney's fees, because ultimately dispute resolution ultimately comes down to who's going to pay attorney's fees, which side is going to pay. Your arbitration clause and your arbitration provision can expressly state who pays. We're under the American rule, typically in Georgia, which says loser pays.
Right.
But in the context of an arbitration, it might be in the best interest of the parties to say, look, we want to efficiently and cost-effectively resolve this dispute, so each party is going to pay their own fees.
Okay.
So there's no risk, to going forward with the arbitration. Now, of course, if you're a corporate in-house counsel, you're going to want to draft that provision to say, if we win, the other side pays it out. So it's on a case-by-case basis how you want to deal with things. But just keep in mind that you can fee shift in the actual arbitration provision itself. Now, the last thing is, after you've entered into the arbitration provision, and as I said again, it's a contract within a contract, when a dispute arises, many people don't realize that the parties can agree to change the arbitration provision after the original contract has been signed. You can stipulate to changes in that arbitration provision, how it's going to be held, where it's going to be held, how many arbitrators you're going to have. Critically, most arbitration provisions include certain particular agencies like the American Arbitration Association or JAMS or certain entities like that here in Georgia. Those entities sometimes may not be a best fit for your dispute. For instance, the American Arbitration Association, they will charge a percentage of your dispute up front before you even get to the arbitration table. So if you can't afford to pay, if you got $1 million case and they're going to charge you 30% of $1 million up front even to bring your arbitration, you may not be able to get a just adjudication of your dispute.
Right.
So you need to remember that the parties after the fact can agree to change what agency, what arbitrator, as a matter of contract.
That's huge.
Yeah, that is pretty big. The other things I wanted to bring up, the second point is how can you change the arbitration? As I just said, you can change the agency, you can change the arbitration format, you can change who pays, you can limit the scope. You can also limit the witnesses and the experts and the evidence. You can literally put in the arbitration provision, all evidence and all documents will be exchanged 5 days prior to the mediation, and these will be the documents that will be the exhibits in the case.
Wow.
So you can literally limit the amount of time that the arbitration takes from the onset to completion in the award. Why is that important? Cost, fees. Many people nowadays who are in arbitration extend the arbitration like it's a mini trial, and the arbitration ends up being more expensive and then actually going to court.
Wow.
So, the whole point of arbitration is supposed to be it's more cost effective, more efficient, and more expedient. However, nowadays, many lawyers that I've seen, I've actually been in cases where they file motions and there's full discovery and depositions and all the like. You can eliminate and eradicate all of that in the arbitration provision clause. Gotcha. The next point I wanted to raise as to this, the third point, would be present a pre-arbitration brief with all of your key evidence to the arbitrator. Focus on what are the most important documents to prove your case.
An outline.
Yeah, an outline. Because arbitrators, when they're looking at a case, quantity is not necessarily a good thing. It's quality. And the other part of it is the arbitrator himself, and this moves on to my next point real quick, is selecting the arbitrator. Having a lawyer is not always a good thing as an arbitrator. Yes, they may know the law and so on and so forth, but there might be circumstances sometimes, for instance, in a construction contract, where an engineer might be the best, most qualified individual to adjudicate the dispute. Because lawyers aren't engineers. They're not geotechs. They're not, electrical engineers. They're not contractors. They only learn what they know from the case itself as they go along. Having an expert PE as an arbitrator can go a long way to cut through all of the non-essentials, and I use that term loosely, in an arbitration, because the engineer says, okay, you've got a flawed deck. This is what the code says. What do you have to overcome this? And all of a sudden, you're dealing with a one-day arbitration as opposed to a 2-week arbitration if a lawyer's there, having to hear all the experts, hearing all the witnesses, and muddling through all of the documentation. The next part is I touched on it earlier about the non-signatories. That is a change in Georgia law that is extremely important for people to know, because if you're a non-signatory to an agreement, sometimes you still have the ability to compel arbitration.
Okay.
The last part I also touched on briefly, the sixth point, are appeals. And I want to talk about this a little bit. Most people think that you can't appeal an arbitration award, that it is final, that it is done, and you're basically out of luck if something is adversely ruled against you. Well, the Georgia Arbitration Code provides for two essential ways to overturn an arbitration award. One, if there's fraud involved, and if the neutral arbitrator is biased in some way or has manifestly not applied the law to the dispute. Those are the statutory ways to appeal. But what many people don't know also is some of the agencies that are out there, AAA and JAMS, they have actually adopted appellate procedures for arbitration now. So not a lot of people know that even exists out there, but there are now appellate procedure rules in an arbitration where if you are dissatisfied with the outcome of the award, or if you want to point out something that went wrong in the arbitration to another independent, neutral arbitrator or panel of three, you can literally go through those procedural appellate rules and perhaps get it overturned. Of course, whatever happens in the arbitration then ultimately has to be confirmed by the court to be able to be enforced and then converted into what's called a fieri facias, a FIFE, or a writ of execution to collect on that judgment. So obviously, arbitration, those are the 6 points I wanted to raise this morning. Not a lot of people know about those particular things, and I just wanted to emphasize those this morning.
Yeah, and I can tell through all the experience that I read from your bio that, obviously you know what you're doing, especially what you just explained and described. So you're obviously a good lawyer, and your next question is, where do you go to find a good lawyer?
Where do you go to find a good lawyer? That's an excellent question.
You have several right here in the room.
I
mean, for a launch show, first show out of the box.
I did pretty good, didn't I?
You're doing all right.
You're doing well.
You're doing all right.
Got the right people in.
Did I give you my business
Listen
card
to the
already?
program.
Yeah.
Where do you start to find a good lawyer? You listen to this program.
Exactly.
That's where you go to find a good lawyer.
That's exactly right. That's what this whole show is about. There are several places that obviously you can go to find a lawyer, many of which are known and others are not so well known. What's interesting about
Not
this...
the internet, I would say.
Yeah, no. Googling is an interesting thing to find out what types of lawyers are out there, but you learn very little in terms of way of experience and knowledge over the internet. What's interesting... Go ahead, Jane.
No, you say what you were going to say, and then I'm going to hop. I'm going to hop in.
Okay, you're going to hop in.
Yeah.
All right. I should say, to preface my comment here in a moment, a lot of people do find me through Google, through my website, and so on and so forth. And we've taken painstaking efforts to get optimal search engine optimization on the website and so on. So you can find a lawyer, but the question is that going to be a good lawyer by going through the internet? Referrals are obviously the number one way that lawyers are found, and when someone feels comfortable with a lawyer, it's usually through someone they know or have been referred to. However, many people out there do not know that there are other resources that you can look at nowadays. For instance, there's an internet website called Avo. It used to be something that lawyers would mock, and they considered it to be, the newest, kitschy thing out there. However, it has now actually gotten some credibility and some momentum, and people are actually putting their profiles on Avo. So it's like a LinkedIn, if you will, for lawyers.
Can you spell that?
AVVO.
AVVO. Okay.
Yeah. And people all over Georgia say, "Hey, I looked you. I saw you on Avo, and I saw that you got a rating of 8.3, which is excellent. And and these are the areas of expertise that you have, and I'd like to come meet with you." Obviously, your Facebook pages and your LinkedIn's and your Twitter accounts are also extremely important when it comes to finding a lawyer. But people also don't know that there are things out there called like Martindale-Hubbell. It's been out there forever. Lawyers know about it. When lawyers are looking for other lawyers, that's usually one of the first places they go to see if they're AV rated or BV rated or what have you. But the consuming public doesn't even know Martindale-Hubbell exists.
Yes, right.
So in addition to those types of websites, there are other things that you can go to. Your Chamber of Commerce, your local Chamber of Commerce. I belong to the Dunwoody Chamber of Commerce as well as the North Fulton Chamber of Commerce, and those places are indispensable resources, not only for business contacts, but also for people who are knowledgeable in the industry and so on and so forth.
The key thing, I think, to underscore for a person who's contemplating why do I even need a lawyer, and what do I want the lawyer to accomplish? And so the easy way to sort of encapsulate what Kurt is talking about is you don't hire a plumber to do electrical work. Right. And so lawyers develop particular types of practice. They have experience with certain kinds of cases.
Right.
And depending on what your needs are as a legal client, that lawyer may be very well suited to helping you get resolution to what your issue is. And
So
unfortunately,
specific to what your situation is very important.
Very
well,
important.
Because everybody's different. Every situation is different.
and so having some sense of what am I trying to accomplish makes determining whether or not this lawyer is a good choice for you a much easier one.
Right.
And oftentimes people, when they're confronted with a legal challenge, he was talking about foreclosure, when you are in the midst, if your life has gotten to the point where you are facing foreclosure, there have been a number of negative things that have presumably preceded getting that notice in the mail. Things are not going right for you. Okay, if you're getting a foreclosure notice in the mail, okay, and if that's the case, you are already stressed, under pressure, panicky, nervous, depressed. You could be having marital problem. I mean, who knows what's going on in your life?
You need a vacation.
Well, and the good news is,
But you can't
you
afford
probably
Yeah,
can't
that's right.
stay where you're living. So,
Right.
but all of that creates a customer, a consumer, who is very susceptible to influence by a lawyer that they get on the phone.
That's a good
Right?
point.
So it may
true.
not necessarily be a good fit for you if you were having more better things going on in your life and everything was
Sure.
balanced. And I'm sure you probably have your own process that you go through. But I would really, really, really encourage people who are looking for a lawyer to talk to more than one lawyer
Absolutely.
Absolutely.
before they decide who it is that they're going to pick. And you would be stunned to find out how often people sign up with the first lawyer they get on the phone.
Really?
The
Yeah.
first one they get on the phone. It's
Wow.
like the legal version of what have I got to do to get you in a car today, right?
Right.
And they finally have somebody who answers their questions, gives them the first glimmer of hope, and they sign up. They don't necessarily ask sophisticated questions about cost. They don't necessarily ask sophisticated questions about expertise. They simply go, thank God somebody took my call.
Someone's going to help me.
Somebody's going to help me.
So
right?
at least 3, I would say, wouldn't you?
Definitely at least 3.
At least 2.
At
At least
two.
2.
At
But,
least two,
you know,
okay.
There's nothing better than that advice.
I mean, it's like a doctor.
That's
you
right.
want at least 3
Second
opinions.
and third opinion.
That's
Yeah.
right.
That's exactly right.
and you'd be stunned how many people don't have, and we see it all the time in medical malpractice cases. After all the bad stuff has happened,
Right.
you have some group of strangers that are in a jury box assessing the way this person made medical decisions, and they think, I would have gone and got a second opinion. And you go, nonsense. The doctor said
Hindsight,
not
20/20.
cancer. You high-fived everybody in the room, and that was the last you thought about it. So, you know, and again, people make decisions using the resources that they have available to them. Some people don't necessarily have a broad professional network and maybe have good contacts about who to contact. They may not necessarily have the same sort of sophistication when it comes to the internet. That's why they sometimes default to television or radio or other types of methods in which to locate an attorney. But really, most important from my perspective is, what is it that you want this lawyer to do? And until you know that, it is really, really difficult to figure out if I have selected a lawyer that's going to be good for me. And then in the end, even the worst lawyer in the world, if they are able to get you the resolution that you want to your individual matter, that was a good lawyer for you for that case.
That's awesome.
And it's not necessarily the outcome that determines what's a good lawyer or not. It's whether the client is satisfied.
That's right.
It's client satisfaction.
Okay,
That's right.
gotcha. Well, tell the listeners how to get in touch with you.
Oh, sure. Okay. Well, obviously, you can go to my website. It's www.hilbertlaw.com. We're also on Facebook. There's the part of my law firm that I'd like to give a plug here if I can.
Sure.
We do a lot of charity work. We have something called Hilbert's Heroes. One of the things after I left a large law firm downtown was I wanted to have more intimate involvement with local charities and nonprofit organizations. So what we did was we created something called Hilbert's Heroes, and every month our staff literally selects a different charity, and we send out a blitz email to all of our clients, which is kind of strange for a law firm because most law firms don't want clients talking to other clients because they start comparing notes and such. I am an absolute advocate of clients talking to clients. That nothing can help your firm more in terms of credibility and understanding and trust.
Especially if you're a good lawyer.
If you're a
good lawyer.
Yes. Yeah. So yes, you can follow us on Twitter. The website is there, and also real quick, we were fortunate enough to be selected as one of the top 101 best and brightest of Atlanta, and we're going to have a show or an event, I should say, in Roswell this evening between 5:30 and 8:30. Where it's business connecting to other businesses under Roswell Inc. Everyone will be there from, Chase Bank to Georgia Small Business Capital to individuals and to nonprofits like Homestretch. So it's one thing that we do trying to help not only the lawyers, obviously, we need to make money off of what we do, but I try to connect dots for the clients. I think that's
awesome.
an extremely important thing. And so we put together events so that clients can talk to clients, because ultimately what happens when clients talk to clients, more business develops.
Yes, that's so good.
So thank you.
Very true.
Absolutely, absolutely. We are over to Bob Williams.
Thank you.
Yes. Welcome.
Sitting here quietly enjoying the conversation.
Do a quick bio for you. Robert Williams began his career in New York on
That's
Wall
correct.
Street.
That's right.
Awesome. Applying this experience and business acumen, Williams now specializes in commercial real estate transactions. He is SBA certified and assists regional and national lenders in government guaranteed lending. He represents national title companies and has issued more than 1 billion policies over his career. He routinely gives title opinions as an expert in litigation cases involving real property. So another expert we have for the
Very
Atlanta
true.
legal expert.
Well, and again, it's not 1 billion policies, but it's $1 billion in policies.
$1 billion in
I didn't want to, but I did want to follow up.
That was kind of
going to be
you put it.
It's my first show, so
Bob's
forgive me.
rather old.
that was going to be a follow up.
I've been called old, but that I think
He has
might
worked
make
for
me
a long
ancient.
time and highly proficient.
That's right. That's right. Well, please go ahead.
So we were talking about foreclosures earlier. Tell me a little bit more about the subject of wrongful foreclosures. Get a little more detailed on that.
Sure. And in addition to doing the transaction work, the commercial transaction work, working with Kurt and the other litigators at the Hilbert Law Firm has allowed me to expand the practice of real estate into litigation as well. And we've handled several wrongful foreclosure cases. Kurt touched on one that he's working on right now that we're all helping with, and we just nearly settled. We're about to settle with another one that really was a true wrongful foreclosure, is where a bank, again unnamed, settled with a...
They're always unnamed.
They were always unnamed. Basically, the bank settled with the client. They said, listen, we know you're behind. We know you've lost a lot of properties. This particular person was an investor. And they said, well, you just give us a certain amount of money by a certain date. We'll give you the property back rather than foreclosing. Okay, so they scrambled. They got the money up. They borrowed from friends and family, and they gave the bank the money.
Okay.
Well, again, little did they know, and little did the bank know, apparently, that the foreclosing attorney never got that notice. And so the foreclosing attorney actually foreclosed the day before the client got the letter stating that if you give us a certain amount of money, we'll give you back the property. Well, long story short, they got the deed marked satisfied, security deed marked satisfied, but all of a sudden they found out that they've got somebody calling them and sending them notices saying, we own the property, get out, get your tenants out. And so, it's your typical worst case scenario.
Right.
Well, one of the things Kurt talked about, and many of the things that banks have to do, is to make sure all of their notices are proper, make sure that all of their advertising is proper, and all of that is part of what Georgia law considers the foreclosure process. And the foreclosure process includes everything from the first notice all the way to the foreclosure itself on the steps, and including the confirmation proceeding, although the confirmation proceeding is usually excluded because of the fact that if everything else went right, they're not going to undo it unless it was sold for too little.
Gotcha.
Talk about the 90-day rule, Bob.
Yeah. The interesting part of the foreclosure process also says that as soon as a bank forecloses and sells to a third party on the steps, and that third party might be the bank itself buying the property back, that deed underpowers what it's called a DUP, because they sold it with basically the power given to them within the security deed signed by the borrower, is required to be recorded in the courthouse within 90 days of the date of the sale.
Okay.
Well, that just
Doesn't
hardly
happen.
ever happens.
Right.
And it almost always takes more than 100 days, maybe even 180 days. The case I'm referring to, it took them 18 months.
Wow.
And long story short is it didn't take them 18 months because they couldn't find the deed. It took them 18 months because they knew they screwed up. And they were trying to
Cover their
fix it.
tracks.
Well, they were trying to
the
fix
problem.
it. They were trying to fix it by either settling with the guy who bought the property at the steps or settling with our client.
Gotcha.
And this goes back to finding a good lawyer, by the way, because these poor clients came to me in,
I was going to ask, when did y'all take over?
yeah, these poor clients came to me about 60 or 70 days after they found out that the house had been sold on the steps. And we explained to them, look, this is probably a fairly easy fix, although that's probably should never be told to a client that it's easy. Nothing is in law. But we said, listen, just let us write a letter to the foreclosing attorney, to the bank, explain what's gone on, tell them they need to undo it or we're going to rain hell on them. And we told them.
By the way, that's a term of art. That's a legal,
That's a
specific
legal term of art.
Absolutely.
That's Latin, but it's don't mean to use Latin in the show, but
That's right. Well, long story short, the client did not do that, and they waited and they waited and they waited and they tried to fix it themselves. And again, I think there's also that other phrase, and even non-lawyers know this, that if you represent yourself, you've got what?
fool for a client.
Exactly.
And you can't fix stupid.
Right. There's not a very good appellate process
That's right.
for dumb.
Well, long story short, it took them 18 months to realize that they couldn't fix it themselves, and they had to come back to us. And then we had to file a lawsuit, and it took, of course, now about 6 months. And mediation, which is another part of ADR that Kurt didn't talk about, but mediation non-binding. In other words, so arbitration binding, except for certain circumstances, and mediation is just you get a third party, usually an attorney that is practiced in the area that you're dealing with. We mediated the case. We didn't come to a resolution, unfortunately, but at least it got the dialogue started, and we ended up with a settlement just recently.
You always
with the
know
bank.
what you're fighting over after a mediation.
Oh, yes, absolutely. So, the all comes down to that foreclosure process. You can actually undo a foreclosure if you can show that there was either fraud, error, what is the third?
Irregularity.
Or irregularity in the process of the foreclosure. And that would include, the wrong name in the foreclosure notice, the foreclosure notice could be the wrong name of the lender, the wrong name of the attorney, the wrong address of the property or legal description of the property.
And
all
also
kinds
the
of
failure to
things.
file within 90 days.
Or the
Right.
failure to file within 90 days. That's
Sounds like
correct.
a key. Yeah.
Well,
point there.
The
But
interesting
you could-
thing about that statute, I'm just going to
Right.
jump in. The Georgia law does not have any teeth to that statute. So if the
True.
foreclosing attorneys don't file within 90 days, the statute doesn't say you can be held liable for exemplary or punitive damages or anything like that.
No, it
Okay.
doesn't.
So what you have to do is you have to be creative to bootstrap that 90-day rule back into the other statute that says, as part of the foreclosure process, there's been fraud, irregularity, or error. Well, irregularity falls under the premise of you didn't file the deed under power within 90 days.
Didn't get it done.
Gotcha.
That's right. And almost all foreclosures, by the way, if you do read the fine print of all the documents they've either sent out to your borrower or sent out to the court or sent out to the advertising, they're in error. There's errors in there.
Right.
You can find them.
So keep your records
but-
like
but-
he said in the beginning.
That's correct.
And I think the key part to take from that, right, is that the legal system, generally speaking, is designed to give some sort of at least process predictability to the resolution of disputes, right?
Okay.
And the more severe the potential consequences to the person being harmed by the action taking, the more accurate or precise you have to be in ensuring that you've done it the right way.
That's
right?
exactly right.
You're taking somebody's home from out from under them, or you're taking a significant piece of property. You better have dotted all of your I's and crossed all of your T's.
Jamie,
because if you haven't,
said it, that's right. You have to have everything right. If you're going to take someone's liberty or property from them, you've got to have every document perfect.
Right.
That's correct.
And so what we've seen with a lot of these is that the businesses themselves, the banks, the processes that they've put in place are unfortunately either being administrated very, very poorly, or it's simply a numbers game. We're going to suck up enough of these properties, and we're going to do this enough times, and there'll be enough people who aren't going to follow the correct recourse. And so even if we get banged a couple of times, few people get the right attorney. Those lawyers find the errors that we made. They then pursue it all the way to the end. At worst, we got to give back a couple of properties. And in the meantime, we have done exactly what we wanted to do, which is basically hit the reset button on a lot of these individual transactions. And that's the part where that person who gets that foreclosure notice, right? This machine has been grinding away behind the scenes, and it was just a matter of time until it came for them and it got them caught up. And the reason why you want to make that phone call and ensure that you've got the right people on your side advocating for your interest is so that it doesn't get you.
Gotcha.
That's correct.
That's awesome.
That's right. And we have all heard about robo-signing. Well, robo-signing doesn't just happen for banks or with banks. Robo-signing happens with those foreclosure attorneys as well, because the attorneys don't have time to sign every single notice that goes out to borrowers.
Their staff are just punching letters and saying that the lawyers have reviewed it before they go out, and when they in fact have not been reviewed.
Wow.
That's correct. And again, that is a failure of the foreclosure process, and that is part of the fraud that makes it a failure of the foreclosure process, which means you can challenge it. And the only way you can challenge it is by filing a wrongful foreclosure action. You're not going to get any kind of remedy in an action if the bank has already foreclosed and is going to confirmation proceedings, which will then allow them to come after you for the money left over, the deficiency.
Judgment.
You're not going to get it at that point.
Gotcha.
You've got to stop the foreclosure.
All right. This is not the area in which I practice, and it's been a while since I was in professional responsibility. So I may be asking what's a fairly simple question. As the lawyer, why is it not an ethical violation to not have your signature stamped on documents?
Well, that's an excellent point, and we'll deal with it real quick because I think you need to get onto your little spot.
No, we're just in general talk now. We're okay. We're general talk
Listen,
stuff.
if you're not signing, if you may be reviewing, your documents online, you're on vacation, you make a phone call, you say, listen, we're giving express authority for somebody to sign for us. That's one thing. But what you may be alluding to is that they're not even reviewing the documents. They're just having their paralegals or even their legal assistants sign these things because they happen to be boilerplate documents. It is, again, when we're talking about foreclosure, it's fraud in the process.
The short and quick of your answer is it is absolute ethical violation.
I would be, if I was the lawyer in that firm, I'd be like, dudes, you got a job for me after I lose my bar card?
That's exactly right.
That's exactly right.
Exactly right.
Unfortunately, the bar doesn't usually come down on the foreclosing attorneys for that.
Well, we as attorneys have a duty to go to the bar if we see something like this.
Right.
And unfortunately, I've come across it a couple of times because these foreclosure firms are mills.
Total mill.
So, and they're sending out hundreds and thousands of these things every month. Mm-hmm. So, but yes, it is in fact an ethical violation. Sorry, Emily.
That's okay. That's okay. So thank you, Bob.
You're welcome.
And I'm sure we can get in touch with you just by the same way with Kurt at the HilbertLawFirm.com.
That is correct. And most of my referrals come from, again, just referrals from other attorneys or referrals from clients that I've had in the past. I don't advertise except through the Hilbert Law Firm. And really, we don't go out, I guess, chasing the business. It seems to find us, and phone calls and people call us every day with their problems.
That's
and
a good thing.
Right. Yeah, that's a good problem.
People didn't have problems, we wouldn't have work. So,
Right.
Just keep having problems.
Well, thank you for being here. And on to Jamie Bendel. Yes.
Let's not do bio.
Okay, let's
We'll
not
not
do
do
bio. Well, tell me about yourself, Jamie.
That's a great first question. All right. So my name is Jamie Bennett. First of all, it's a great pleasure to be here
Yes,
on what
I'm
is
so
this
glad.
first program, and I hope that everybody appreciated the terrific information
Absolutely.
that these two gentlemen
We could
were
go
able-
another hour with that, for sure.
Yeah, it is such a complex topic. It's one that people have real and legitimate fears about for a variety of reasons. And unfortunately, not necessarily speaking on behalf of those who find themselves in the foreclosure process, but sadly, I think that we sometimes have a certain amount of stigma that is associated to people that find themselves in the foreclosure process, and they alluded to it a little bit in there. The reality is, and it's really, I guess, the point that I would want to touch on most specifically, is it is more common than not that people didn't anticipate finding themselves in this circumstance.
Gotcha.
People go into business deals assuming that everything's going to work out and I'm going to get along with my partners and it's going to go gangbusters. People make the assumption that I can afford this house and because my life circumstance is going to be reasonably consistent, and then it doesn't. In my case, when it comes to personal injury matters, folks are minding their own business, and through no fault of their own, they're harmed because somebody else failed to do something.
Right.
And so they weren't anticipating. They haven't, Clark Howard never on his program, or Dave Ramsey, whomever your preferred financial advice person is, Susie Orman, doesn't say, pay yourself first, save for retirement, and set aside 5% of your income for a litigation fund, because you may someday find yourself involved in a lawsuit. It doesn't work that way.
Right.
Something happens. And then all of a sudden you have to go through the process of figuring out, how do I work my way out of this? And it is not uncommon for people to assume that they can utilize basically what amounts to self-help. That this company, the bank, this insurer, the doctor is going to do the right thing. And what they find is that what they think the right thing is and what that person on the other side of the dispute is are two very different things. Totally different things. And they will work through that for some time period, and then they call the lawyer. And so I think if we ask the question, it's very rarely does the person call and say, tomorrow, I think I would like to do this. Instead, they say, for the last 6 months or 89 days ago, and they call right at the finish line. And a lot of times for lawyers, and we talked a little bit about the grievance process, and it is a topic
Grievance
for another
or grieving
day.
process.
Yeah, grievance or grieving. But really, many people don't know this, but one of the reasons why lawyers will sometimes say no to taking on your matter is because it is really cheap malpractice insurance to say no. I don't, if I know, and of course, and again, some of this goes in the context, and some people may or may not know it, but no matter what the legal matter is, there is an established, predetermined time period by which you need to get to the courthouse, raise your hand, and say, I've got a claim. I've got something that I'm disputing, right? And if you don't, you may never have the opportunity to ever get it resolved the way that you would like it to, right?
If you don't mind, what are some situations that people go through that they don't realize they could actually get a lawyer? Like, what are some common situations where they, like you said, they wait till the very end?
They wait all the time because they
It's
don't
pretty
know.
much every
It's
case.
every case. It's every case, right?
They're afraid. Lawyers are expensive. There's no doubt people shy away from lawyers.
And lawyers have a stereotype that they're going to blood suck the client. So the lawyers are the last person they want to go to, even though they're the first that they should contact.
Should go to.
Yeah. And again, one of the things which is interesting, so we're here on business radio, right? You would be surprised not to people often overlook lawyers as part of a community's business community. Right? They somehow put them in a different category.
Kind of like doctors.
Doctors they assume are in business, right? Because they
that's
have
true.
the
That's
doctor
true.
has
Yeah.
a business, but they overlook the fact that the legal community in any town is part of the business community. Though they're employers, they are business owners, and the job that they do is legal in nature.
And they're business connectors.
But they connect people together, right? And so, as a result, people shouldn't be afraid to contact a lawyer, because the worst that will happen is they will find out that maybe that's not a good fit, right? And and listen, qualifications notwithstanding, right? A person who's listening to this show has had 3 different lawyers speak, and they may identify and say, boy, I would feel comfortable with this guy. I don't feel comfortable with that guy, right? And it's just from the way we express ourselves, right? So again, I think that people should not have fear as it relates to contacting a lawyer. You should never, ever, ever apologize for pursuing defending your rights, protecting yourself.
And if you get judged by the lawyer for that, that's probably not a good lawyer for you.
All right.
Right.
Well, you seem
Move on.
passionate. You seem passionate, especially with the personal injury. And I saw some of the stuff on your website, and it was talking about the specific injury cases that you deal with that are really awesome. And I wanted to find out, why did you become a personal injury attorney? And obviously you have a passion for it. And
Okay. So in my circumstance, I'm from upstate New York originally, and my father was a lawyer. Okay. In fact, we practiced together. So what I heard around the dinner table was all of the cases and all of the various things that happened to the people that he represented. And one of the things that I liked about, and we made reference to the fact that one of the neat things about our system is that you don't, in fact, necessarily need a lawyer. If you chose to, you could defend yourself in court. You could assert your rights, protect your rights. You could be there by yourself. And instead, some people, the majority, I guess, would prefer somebody else do that for them. So to me, there was this great sense of honor and to be asked by somebody from within your community to say, I have the right to speak for myself, but instead I would like you to do it for me.
It's humbling.
It's to me, it's a tremendous sense of responsibility. It's one of the reasons why it's easy always to do, in my view, the right thing as a lawyer, the ethical thing as a lawyer, is because I am here on behalf of somebody else.
Sure.
Right? I am their spokesperson.
And their life is in your hands.
And it may be the only
Literally.
time they ever interact with the legal system. It
true.
may be their one and only time. Which again is one of the things that also makes it very difficult for them to determine, is this a good service provider or not? If you call an HVAC guy to come and fix your AC and they don't, the likelihood is, I'm not going to call that one again, right? But in the legal context, you may never have a need to hire that lawyer again. So you have a really hard. I've never priced out a broken leg previously. I don't know what a good outcome for that is. I haven't sold my business before. You know, it's so there are these factors that come into play a little bit differently, and I guess in some respects it's a little bit like medicine, right? You go to a doctor, you see them for their bedside manner, particularly a general practitioner, and for the most part, you get well, right? And if you like them and their practice runs well, you'll go and continue to see them. In a city like Atlanta, you may have clients that are very close to your office. They move to a different part of town, and they assume, I have to get a lawyer. I lived in Duluth, but we moved to Kennesaw. I guess I got to get a Kennesaw lawyer. But again, that stems from treating lawyers like you treat a dentist or a plumber. You know, there are all these different things that come into play. So in my case, as a child, I had the very good fortune that my father structured his practice in such a way that he was able to coach the teams that I was on, the teams that my brother was on. He was home for dinner.
That's awesome.
It sounded like the practice was really sort of interesting. I was always curious the numerous ways that people found themselves injured or harmed, the craziest fact patterns that he would discuss, and it seemed like a good fit. And I'm thankful to be able to do that now.
That's awesome. And I cannot let you go without asking you about the punchline. We got to do a little comedy here.
Okay, so
Save the best
Maybe
for the
some
last.
attorney
Yeah.
jokes.
I thought we've been doing comedy.
yeah, right. So we didn't really touch on it a little
Yeah,
bit. We
how did
briefly
you
touched
get
on it
to
in a little bit of Loser Pays. I started doing stand-up comedy when I was an undergrad here in Atlanta. Decided to go to law school as well. Went to law school out in California. Went to Pepperdine. So I was a law student by day, comedian by night.
I love that.
And
So crazy and awesome at the
You'd be
same
surprised.
Yeah.
It's a very common.
We all have
thing.
other lives
Yeah,
outside of
there's
the
a
law.
lot of folks that
lawyers
a lot of
are
lawyers
comedians.
and the reason
They
for
are
that
funny,
is
too.
there were jobs,
They are.
right?
Yeah,
And
yeah.
lawyers oftentimes see that lawyers. I would suggest you make terrible audience members because we're wicked analytical and we tend to think pretty quick and we want to know how things turn out. So when Georgia was considering some, in my view, reasonably onerous tort reform, we realized that our practice had the potential to be limited by things outside of our control. And so we wanted to diversify a little bit. And so I had been a comedian. I obviously had been in Atlanta for a long time. The Punchline, the folks who had originally owned it were up to selling it, and we were able to. And I figured
that's awesome.
in worst case scenario, even if I was terrible at it, so could be somebody else who bought it. So I could either keep it going or I would crash it into the bridge, just like
And go
somebody
back
else
to
who knew
practicing
nothing about
So
this. Yeah.
let's finish it up. So how can the listeners get in touch with you?
All right. So the firm is Bendel Mennick. Our practice is personal injury. I recently just completed my registration process with the Office of Dispute Resolution. So I'm looking to get into the
Congratulations.
Come join me.
mediation field. I'm excited about that. Our website is reallawyers.net. And the website for the Punchline is punchline.com.
Awesome. Thank you so much, everybody. Thank you for listening today. We look forward to being back next week with some more legal expertise from the Georgia Trial Lawyers Association. That's going to be a good one. This is Emily Rowell with CrownOfficeSuites.com signing out.